Hey guys, welcome back. Hopefully you did well on your quiz on the president. And you're going to see that I posted an assignment, a project of sorts that you're going to do your own president project. But now we're going to move on to Article 3 of the Constitution, which is the federal court system. This video is going to be a lot shorter than the other ones because this section is a lot shorter than the other ones. The founding fathers kind of got to the point after taking care of Congress and the president where they just didn't feel like doing this anymore and made everything really, really short from this point on. So this one's not going to take too long. The founding fathers knew we needed a federal court system, right? It was something that didn't exist under the Articles of Confederation, and it was something we terribly need to handle disputes between states because they just weren't listening to us. But the problem here is you want it removed from the people, unbiased in its opinion. So we're going to remove it from the people's selection. The people have no impact whatsoever on the federal court system, and we'll talk about whether or not that's a good thing. But basically, what the founding fathers did was they created in Article 3 a Supreme Court and then said, okay, Congress, you do the rest, and we'll let them figure it out in the future. And there's a series of laws that they'll pass that we'll talk about that did that. But if we look at the Supreme Court, that's the building that's right in front of you. It is the national court. It is the highest court in the land, and it is responsible really for not hearing many cases. It really doesn't. They only hear about 700 cases a year, which might seem like a lot, but it's really not. And there's two types of cases that come before the Supreme Court. One is original jurisdiction, which really doesn't happen all that often, and the other is appellate jurisdiction, which we're going to spend most of our time on. So original jurisdiction means this case goes directly to the Supreme Court. If you commit a crime in Warwick, you'll be dealing with the Warwick magistrates or even the state of Rhode Island. There are certain cases that involve the Supreme Court directly. Those are any kinds of cases involving crimes with ambassadors. Anytime a state is a party in a lawsuit, it goes before the Supreme Court, or anytime there's a public official involved, a member of the government. For the most part, it almost never happens. The more likely one would be the state. If you were to sue the state of Rhode Island, for example, it would go then to the Supreme Court. The one that we hear about all the time in the news, this is what you might not have realized, it's called appellate jurisdiction, meaning there are appeals that are heard from lower criminal courts. And I'm going to show you just what that looks like right here. So what happens is a court case happens at the state level, right? Some kind of crime has been committed at the state level, and you are convicted of a crime. Now, let's give the example that you committed a carjacking crime, right, in the state of Arizona. This is a real-life example. You'll see where I'm going here. You committed a crime of carjacking, but you were not aware that you could have a lawyer. You were convicted in the state of Arizona. You then find out that you can have a lawyer present. So you file what's called an appeal, and that goes then to the state court of appeals. So the state will hear it. And let's say they say, no, you still don't get it. Well, then you appeal to the next court, and you keep going up and up and up. You go through the state Supreme Court, you go through the federal trial court, and eventually you go to the U.S. Court of Appeals, and lastly, the Supreme Court. And this is how it works, right? If you look at this chart. So any kind of federal crime would be at the district level in the green here, right? So a terrorism, for example, right, would happen in the green. Then let's go back to that case from before. If you're appealing, there's some kind of constitutional issue or some kind of legal issue that you want to bring forth to the court, it's heard in the blue, which is the Court of Appeals. Now, the court that I talked about, the case, is Ernesto Miranda in 1972. He sued in the Court of Appeals and then all the way up to the Supreme Court where they heard his case. Now, how do you get a case heard before the Supreme Court? Well, what you have to do is you have to file petitions. It's called a process of certiorari. And there are tens of thousands of cases that are filed every year with the Supreme Court. And the justices that are on the Supreme Court, I'll talk about them in a minute, there's 9 of them. They get to pick what cases they want to hear. And basically, they just pick the cool ones that have major constitutional issues or major legal issues that can set what's called precedent, right? So in the case of Ernesto Miranda versus Arizona, he was not aware that he could have a lawyer present during questioning of police. So what we get now from that ruling is what's called the Miranda rights. And if you're a Law and Order fan, you know exactly what I'm talking about, right? So the Supreme Court can issue rulings and issue decisions on constitutionality. And we'll talk about that in a minute. How do you get to be a Supreme Court justice? Well, there's really very few restrictions. Really, the only thing you need now is to be a certified lawyer, but you're appointed by the president, who then must have his appointments confirmed by the Senate. Remember, we talked about all presidential appointments require approval by the Senate. Judges can be impeached, just like the president can, if they commit some kind of crime. And then what happens below that is there's a bunch of other federal courts. So it's not just the Supreme Court. If you look back at our image very quickly, right, you'll see that there are tons of different courts all over the nation, right? There are 12 regional courts, those are the appellates, and there are 94 district courts, right? So if we go think back to the Marathon bombing, right, Dzhokhar Tsarnaev was tried in district federal court. We're District 1 in New England. So because he committed a crime of terrorism, that's bigger than Massachusetts. So that would be held in that position. And those are federal judges, all of whom are appointed by the president, confirmed by the Senate. Now, what can the Supreme Court do? Well, not a lot. They can only hear cases that come before them. They can't go out and say things are illegal. They can only have them brought to them. And I'll give you some examples, right? So the biggest Supreme Court power is what we call judicial review, right? Once you're appointed a Supreme Court justice, you cannot be removed by the president. So if President Trump appoints someone and then the next president's a Democrat, they can't remove that judge. They serve for life unless they resign, are impeached, or die. Right? And they have the power to basically look at court cases and determine constitutionality. It's a pretty interesting process. You can see the justices here on your screen, the 9 judges. Generally speaking, they're a little older. They're very seasoned judges who have a lot of involvement in case law and have really made a name for themselves. But their job is to interpret the Constitution, right? So if a case comes before them, they have to decide whether or not there's a constitutional issue here and what did the Founding Fathers really want, right? And we can look at some very famous cases that the Supreme Court is involved in, right? Roe versus Wade, 1973, talking about legalizing partial abortion. Right, we have Brown versus Board of Education, 1954. The Supreme Court ruled that segregation was unconstitutional and not something the Founding Fathers wanted. Right, there's endless examples of these kinds of things, good and bad. We have 1857, Dred Scott versus Sanford, when the Supreme Court said that African Americans aren't granted the status of citizenship. Right, obviously a big mess up by the Supreme Court, but they, for good or for bad, they can interpret the Constitution, which means there's human error involved there, right? But basically what happens is if someone brings a lawsuit before the federal court, they can judge an act of Congress or an act of the president to be unconstitutional. We call it judicial review. And in our next chapter, we'll look at the exact case where this happened. It was called Marbury versus Madison. But it established the power of the Supreme Court now to basically make its own kind of laws, right? It sets policy, what is and what isn't okay, right? Certainly upcoming legalization of marijuana, gun control, right? Immigration and border status. Those kinds of things will be cases that will eventually, it takes years, but eventually will work their way up the Court of Appeals, get to this big white building you see here, and eventually the Supreme Court will decide on constitutionality. And that's really its job, is to interpret laws. Right. If we look at the rest of the Constitution, Articles 4 through 7 are much, much shorter. Really the only one that matters for right now is going to be Article 5, which has to do with amending the Constitution. Right? How do we change it? The Founding Fathers allowed for 2 systems by which we can change the Constitution if we want to. If the will of the people is very clear. Right. The first one is the congressional method, which is how most of them occur, which is an amendment is submitted just like any bill. Right. It requires 2/3 approval of both houses, like you can see up here. Right. 2/3 approval of both houses. And then it goes to the states. And you need 3/4 of the states, 75% to approve it. That's really hard. Right. 67% of Congress, 75% of the states. We've only had a few, and we're going to look at some of those amendments. But it's a really hard process. The other way is called the convention method, which actually only happened one time with the 21st Amendment. You don't really need to worry about it. But mostly it starts with Congress and then goes to the states. The last thing I want you to know is called the Supremacy Clause. Incredibly important. And this basically says the Constitution is the supreme law. Remember, when we talked about the Articles of Confederation, the states were supreme, and that was a problem. So the Supremacy Clause, Article 6 says no. Constitution rules, then federal laws, then any kind of foreign treaty, then the states. But states can't make laws that violate any of those three, right? So the federal government really has major supremacy here in a way that we did not see under the Articles of Confederation. Our last topic that we'll do on this chapter is ratification, which we'll talk about next. And that has to do with the Bill of Rights. One last thing I want to mention, the Founding Fathers eventually got this whole Constitution signed, right? September 17th, 1787. There were some men who refused. George Mason of Virginia famously said he'd rather cut off his left hand than sign the Constitution without a Bill of Rights. And that's really a segue into our next topic. And of course, the Founding Fathers had to go to City Tavern, which is the same spot they signed the Declaration of Independence, to celebrate the signing of what is really the principle and really the apex of democratic government in the world.